So this second panel is addressing the question, are First Amendment values under siege? Vince Blasi, who has been a law professor at Columbia for 34 years by my count, is our moderator, and I'll let him take it over. Thanks very much.
At the risk of widening even further the pessimism phenomenon, my particular interest is history of ideas, and in an era before the digital age, some of these concerns were raised, and I want to just begin by reading what one critic had to say. Nothing is now read slowly or twice over. Books are run through with no less rapidity and scarcely leave a more durable impression than a newspaper article. When every unit is individually weak, it is only multitude that tells. What wonder that the newspapers should carry all before them? A book produces hardly a greater effect than an article, and there can be 365 of these in 1 year. He therefore who should and would write a book and write it in the proper manner of writing a book now dashes down his first hasty thoughts and what he mistakes for thoughts in a periodical. And the public is in the predicament of an indolent man who cannot bring himself to apply his mind vigorously to his own affairs, and over whom, therefore, not he who speaks most wisely, but he who speaks most frequently obtains the influence. That's John Stuart Mill lamenting how ideas were considered in his age, and was written in the Westminster Review, April 1836. So, now our assignment is to address the question, are First Amendment values under siege? But I was so impressed, and I mean this sincerely, by the first panel that I want to alter the military metaphor just a little bit and ask our panelists to begin with the question, not strictly speaking are First Amendment values under siege, but is First Amendment doctrine, and maybe even First Amendment theory, something of a Maginot Line that is deeply built in and more or less impregnable against a direct assault, but very vulnerable to a flanking action. If the real problems are things such as distraction, surveillance, how much work does the First Amendment, as we have understood it, both theoretically and doctrinally, doing? How much is it capable of doing? Or conversely, have we overestimated the degree to which First Amendment doctrine and theory provides a sturdy defense against a direct assault? So that's where I'd like to put the first question. Let me begin with Leslie Kendrick.
Thank you, Vince. First of all, I just want to say it's such a pleasure to be here. I want to thank Columbia and the Knight Institute for this opportunity. So, Vince, I think your intervention and revision of the question is well taken. And in fact, when we got the title for this panel, our First Amendment values under siege, I thought you could equally ask, are values under a First Amendment siege? And by that, what I mean is this. You know, to answer the question, are First Amendment values under siege, I think one thing that's interesting is I don't think any of us think that the rhetoric of the First Amendment is going anywhere. It is not as though the First Amendment is likely to disappear from public discourse in the way that, say, economic due process disappeared from public discourse. That's not the situation that we're in. Instead, we're in a situation where I think First Amendment values can be a shield for things that many people in this room probably think are quite important, but can be swords for other types of purposes. I think you see this a lot in public discourse where people claim essentially immunity from criticism on the basis of the fact that they're exercising their First Amendment rights, as though everyone equally deserves a pat on the back for speaking their mind, as though we're forgetting that the Nazis march at Skokie not because we agree with them, but despite the fact that we disagree with them, and not everything that's protected by the First Amendment should receive normative endorsement. But leaving public discourse aside for a bit, I want to suggest that even when it comes to courts and judges, the idea of what the First Amendment is and what it protects is something that's open to question in ways that I think we should recognize and think critically about. So here are just a few quick examples. One, the Supreme Court case United States versus Alvarez, in which the Supreme Court finds quite a robust right to lie, unless your lie takes place in a specific context where there might be specific individuals hurt by it. The diffuse harm of just lying to the public apparently is not a cognizable harm under the reasoning of Alvarez. This is an attitude that might make sense in one context when we're thinking about the lies that we tell each other at cocktail parties, and takes on a quite different aspect when you have people writing completely fake news articles out of whole cloth and able to publish them in ways that look legitimate, are very different and difficult to distinguish from real news outlets, and able to disseminate them very widely. Second example, the recent immigration ban hearing, the case in the Ninth Circuit, a dissent by Judge Kaczynski, who says, you know, you really can't figure out the purpose of this ban by reference to the president's campaign statements. And one reason he gives for that is to do so would impinge upon the president's and other candidates' ability to exercise their right to free speech. So he cites McCutcheon, a First Amendment case, and suggests taking candidates seriously has some sort of bad effect on their exercise of their First Amendment rights. Now, there may be problems with discerning the purpose behind either executive orders or legislation through campaign statements, but I tend to think it's not a First Amendment problem. The argument that somehow it's a First Amendment infringement to take candidates at their word seems to me a perversion of what it is that the First Amendment is supposed to be about. Final example, lots and lots of different types of commercial interests have argued that the First Amendment immunizes them from having to provide information to the public. This is labels on, beef labels, labels on meat, posters in workplaces describing labor law. It's net neutrality. Verizon and AT&T arguing not only are these laws incorrect from an administrative law perspective, it violates our First Amendment rights not to be able to throttle content or block content. Where in the case involving the Associated Press, the antitrust case from decades ago, the court said, we don't think it's actually the Associated Press whose First Amendment rights are at issue here. We think it's the First Amendment interests of the public in receiving this information that should get attention. And here you see an inversion of that, where it's the content providers who are arguing they have a First Amendment right to decide what type of information everyone else gets. So these are just some examples of arguments that are being made in court, both by litigants and by judges, where you might think First Amendment values are at odds with larger democratic values, and that's just a piece of this puzzle that I want to add to the table. Not, I hope, to provide a distraction. I'm not trying to distract from the question of are First Amendment values under siege. Instead, I want to posit we might be seeing something that looks a little bit more like what I call kind of a donut First Amendment. Or this is New York, so maybe it's a bagel First Amendment, where the core press protections, protection for factual information, protection for speech that criticizes and questions the legitimacy of government policies is eroded in various ways, which we will flesh out here. But protection at the periphery for beef labels, for lies, that stuff seems to be growing as the middle gets hollowed out.
Why do you think that protection at the periphery weakens the core? You have an article in the William and Mary Law Review, First Amendment Expansionism, that I think is a really insightful account of this phenomenon. But say a little more about, should we think that the core values are weaker as a result, or is the only real cost of First Amendment expansionism, that competing, other kinds of values, the value of majorities being able to regulate the economy or whatever are weakened. But is the core weakened by this expansionism?
I'll be really brief because my fellow commentators have way more interesting things to say about all of this.
Follow up on that.
I think of you, Vince, as having put forward a persuasive case that expansion can lead to destabilization at the core. I'm agnostic as to whether these things are related. I think you could have, and we had up till fairly recently, a fairly strong societal consensus about press protections, for example. And you have people like Mitch McConnell who would say, well, I want protection for campaign finance, but what that means is that I have to sign on to protection for flag burning. And there was a kind of package deal where expansionism, I think, didn't necessarily mean destabilization at the core. I think it's kind of an empirical question about how societal attitudes work through these things. But one interesting thing I think about the advent of Trump is here's someone who says the press is the enemy of the people, while at the same time, judges are giving him essentially First Amendment protection to say whatever he wants on the campaign trail and not hold him accountable for it later. So I don't think it's necessarily the case that you would have these things fit up in this way, but we might be at a moment where they are.
Jeffrey, are First Amendment values under some kind of siege?
Yes, I think we're in for a fight. And one of the reasons that I traveled from Austin, Texas to be here is to stay within this metaphor, to stand at the Knight Center barricade and have cause for optimism that there are these barricades that I think will hold the women's marches after the inauguration being a sign of some robust thing. But I think the siege, I think, starts with this. To go back to your Maginot Line. We're all familiar with the First Amendment doctrine that is impregnable, but depends on distinguishing tolerance as an ethic from respect. And I don't think that's going to serve us well. I think the law here requires attention to the state of the democratic civil culture. Now, tolerance is simply a non-judgmental standard. We all know it as, I don't have to agree or even like. I might despise your ideas and your stance, but I tolerate your right to say it. The most recent case of that is this case, Snyder versus Phelps, about protecting the right of the Westboro Baptist Church to be on public property and picket a military funeral to the distress of the parents. You can imagine what it would be like to have your son's funeral picketed by a church, hijacking it for a protest about gay rights that have nothing to do with their son. But that's an example of tolerance. My fear at the meta level is we are becoming a culture in which our ability to respect and flourish within our diversities, to really respect our differences, to learn from our differences, to know from our differences, is really, there's a perfect storm of factors that are weakening that Maginot Line by leaving us with an ethic of tolerance, but our ability to genuinely respect what a democracy is in terms of the equality of people coming together. I think that that is under siege. I'll just tick off some factors that maybe we could come back to. So the perfect storm is a combination of political, economic, technological, and legal factors, and cultural. We have a kind of political scapegoating on steroids that is totally devoid of any respect for the work of journalists. I don't think we've seen that before, and since we're in this room, ancient tyranny was not ideologically driven. It was simply driven by this pandering to the people by holding up some scapegoated group that they could totally demean And we've seen this turned against journalists in phenomenal fashion. Economically, our moderator, Lincoln Kaplan, told me over dinner last night that 42% of jobs in accountability journalism have been lost in the last decade. Lincoln defined accountability journalism to me as simply speaking truth to power. If that's the case, that this is a profession that has lost nearly half its core jobs without any legal threat, that's an economic threat. We have a technological threat that the first panel spoke about. You have a democratization of information that's supposed to serve the connection between speech and democracy, but I think there are lots of reasons to think it's in fact severing rather than serving the connection between speech and democracy. For all the reasons that the first panelist spoke about, and I'm just going to give one example and then pass the baton. I am concerned about the Gawker decision in the Hulk Hogan case. This is a case in which Gawker posts a sex tape of the professional wrestler Hulk Hogan, and he sues and wins before a jury for, let's just say, privacy violations, that this is not a newsworthy event. And here I think we see the legal work that needs to be done. Any decision that says the press can be published for publishing the truth is a very serious thing to take, to move to a doctrine where the press can be published for publishing the truth is problematic. On the other hand, for reasons the first panelist I think spoke about, it's hard to defend that Maginot Line in the case of Gawker. It's hard to think we all should get into that particular bed and have no kind of sense of journalism that distinguishes between where we started in New York Times versus Sullivan, which is the core connection between speech and democracy, and the phenomenally weak connection to the detriment of privacy if you're speaking about a sex tape of a public figure, but certainly not a public official. I don't know how to struggle with that connection between the value of truth as we inherited it and the value of privacy. And like Leslie, I'm extremely worried about the loss of accuracy in this new technology when the gatekeepers that accountable journalists used to provide, that gatekeeping function, has all been lost in the world that we inherited, and new gatekeepers, first panelist, Google's control over search, have tremendous unaccountability.
Let me bring Suzanne into the conversation. Professional writers traditionally have been among the more important gatekeepers. Today, they also seem to be filling a different role of being convenient scapegoats. Looking at these First Amendment questions from the standpoint of writers, what's your view about what the most important threats are today?
Yeah, sure. I mean, one observation I have is, as many important, pressing First Amendment questions as there are, and you've touched on a number of them, there's so many issues, I think, relative to what we think of as a kind of an open marketplace of ideas that where the First Amendment is really, virtually silent. I mean, we had our big gala the other night, and John Sargent, the publisher of Macmillan, wanted to talk about the Milo Yiannopoulos dilemma, which was something that kind of roiled the publishing industry. And so he, looked up the First Amendment to sort of see what it would say, and he found, he was surprised by just how brief it was and how it imposed no obligations on him. And, he talked about it as a kind of moral obligation, but I think that's, whether we're talking about internet trolling or fake news or the predominance of Google or Twitter, or even many of the issues surrounding surveillance and privacy, it is difficult or impossible to kind of articulate a First Amendment analysis or how the First Amendment is even relevant to keeping our kind of flow of ideas and an open society that we're all kind of struggling to defend in this moment. And so, you know, where do we go? Where do we look for the kind of precepts and pillars that can defend against some of the things that we're concerned about? You know, there's international law, but that's never had much resonance either legally or culturally here, even though it does elaborate some of these ideas much more fully. But, you know, I think it comes down to sort of how we, at a social and a cultural and an educational level, you know, come to talk about and appreciate these elements of an open society. I mean, we've done a lot of work on free speech on campus, and that's another area where, you know, the First Amendment kind of comes into it, but often marginally. It's often, you know, first of all, it's private versus public university, and then even at the public universities, you know, much of the time it's speech against speech.
Yeah.
It's permitted protests or hecklers or, you know, people trying to obstruct Charles Murray. They're exercising their First Amendment right, you know, up until the point where, you know, they become violent or threatening, and yet they can pose a really formidable barrier to free speech, you know, not just there, but on other campuses around the country that play copycat. So, you know, it poses a challenge both in terms of, you know, how to find the precepts and also how to mobilize the energy. One of the most distressing things that we've heard in the course of our work on campus speech is young students, and particularly some students of color, student leaders who've been at the forefront of these movements and efforts saying the First Amendment wasn't written for me. It means almost nothing to them. And what they, you know, they mean a couple things by that. They're 3/5 of a person when the amendment was adopted. But more than that, the way they hear the amendment being invoked on campus is to protect, you know, speech that may be racist or sexist or in another way offensive. So they've not had occasion to think about how it protects their ability to protest or to wear a hijab or to criticize the president of the university. And so there's a deficit of information and understanding at work as well.
Do we have really two First Amendments in a way? One, a set of principles and traditions relating to limiting government power to regulate, basically what we think of as the law of the First Amendment. And second, a series of social norms that we believe have real content and ought to constrain various private actors, university officials, or even individuals deciding how to treat others who have ideas they take to be offensive. And if there are, in that sense, two First Amendments or two free speech principles, how do they relate to each other? Certainly, principles designed to limit government are going to be richly informed by phenomena such as distrust of government, limitations in terms of what can be proven in court and what remedies are efficacious and so forth. You might think that the private sphere of speech regulation, if we want to call it that, might be different in some detail. Jamal, I don't know if you want to address this, but I'd be very interested in your thoughts on that question.
So I think certainly as a matter of tradition, as a matter of legal tradition, we've understood there to be more than one First Amendment in the sense that that suggests, Vince, that there's the world of legal regulation of government, legal constraint on government policy, and then there's a whole social universe that involves private actors. I'm inclined to think that that's a limitation on our imagination, and that if we continue to think of the First Amendment in only those terms, we're going to continue to be frustrated. The fact of the matter is the First Amendment can be understood as protecting a very wide range of values, and protecting those values not just in the sense of preventing the government from regulating, but in the sense of providing, assuming the government has some duties or obligations to provide a space for free discourse. That's not how the First Amendment has been understood traditionally, but that's on the table. And I think it has to be on the table if we're going to understand this problem in anything but very narrow terms. The First Amendment has been understood to protect individual self-expression, to protect the conditions for democratic will formation, to protect a certain tolerance. I know you've written about this a bit, Vince. I and anyone on this panel, and certainly any lawyer in the room, can easily think of ways in which you might regulate speech that would be either destructive or in the service of those values. Right. So if I decided to pass a law that said you can only follow 50 people on Twitter or something, which would be an obvious affront to the First Amendment in some sense, it is also quite in the service of deliberation and other values that we think the First Amendment is designed to protect. Right. So if we continue to think of there's this thing called the First Amendment, and it is government censorship of political speech, and everything else is just some kind of interest the government has or interest that society has. Then I think that's going to end up being too narrow to try to treat the kind of problems that have been identified in this room. I'll also say, we've been talking about optimism and pessimism. I tend to think that we should be wary of perfect solutions or wary of the notion that there's going to be a good answer to these questions. If you democratize freedom of expression without censorship, it is going to be very difficult to have a conversation. We don't trust the censors, and we have good reasons not to trust the censors. But that's going to require a very delicate balance of a lot of very contextual factors. Our First Amendment doctrine, to go back to Vince's original question as to whether doctrine is up to this challenge, our First Amendment doctrine tends to be fairly categorical, right? The question a judge wants to know is, does your speech or does this actor fall into the category of what the Constitution protects? If not, we're going to kind of let the regulations fine. If they do, the regulations presumptively problematic. I think we need to think in a much more nuanced way. And so, going back to these examples of lies, or the example of the Gawker case, right? It will be the case that sometimes lies are perfectly innocent. Sometimes it's totally inappropriate to regulate lies, and sometimes it is appropriate to regulate lies. And if we think about the First Amendment as a kind of on-off switch, rather than in a much more contextual way, we're going to have this kind of problem.
I want to go back to what Jeffrey mentioned, that tolerance is something that in some ways doesn't come naturally. That most of us, when we tolerate something that we think is really important and really wrong or harmful, it's a matter of submitting to a moral constraint, and we sometimes do it and sometimes are incapable of doing it. Is it the case that this struggle to follow principles in this realm of private potential regulation of speech has become more difficult, perhaps for some of the reasons that were mentioned in the first panel, or on account of other phenomena, political polarization? So do we have a much harder challenge, really, to keep alive principles of toleration in our private interactions when it's not a matter of court principles leading to decrees? Anyone want to speak to that? It comes up a lot, of course, in university regulation of speech, but there are lots of other settings where that's true too.
I think there's two countercurrents almost that I see. I mean, one is among young people, there's sort of a radical tolerance that is coming into being that you hear, when someone gets up and talks about, all the categories of, that they fit in and all the categories that they want to see tolerated and welcomed and embraced, all the categories of gender and sexual identity and race and undocumented immigrants. And like there's a kind of intrinsic understanding, when I hear students speak, that you have to kind of encompass and embrace and defend all of that all of those identities need to be respected, and that if you're a gender rights advocate or a racial justice advocate, you've got to kind of make space for all of that in your worldview. So I think, that's to me a very hopeful aspect of this, which is I think there is a kind of deeper level of, not just tolerance. I mean, to your point about there being tolerance and kind of understanding and respect as a further layer above that, I think, that is emerging. There's some strains of that. There's also this very powerful countercurrent, which is, in our work on campus speech, looking at the demographic changes that are taking place in our society and kind of more rapidly on campus, where we're becoming majority minority as a nation, and white Americans will be in a matter of a couple of decades a plurality rather than a majority, and that's already the case on many of these campuses. That requires some rethinking of how the university operates, what it takes to make people comfortable in a classroom and able to participate fully. And then on the flip side, there's a very entrenched kind of fear and resistance to that can stoke intolerance and lack of respect and understanding and a kind of very harsh backlash. So I think there are those two kind of countercurrents that we see in tolerance. I don't know what, if anything, our law, obviously we have plenty to say on non-discrimination, but this deeper level of sort of psychosocial understanding and appreciation is something that I think is hard to legislate or regulate.
Jeffrey, you have anything?
Well, let me ask Suzanne a question then about campus speech, and just to take that example. So I find myself teaching at the University of Texas after a lifetime of teaching in private New England colleges and universities. And protests at the University of Texas are a different kettle of fish than what I was used to. So what do you do with an example like this? To its credit, the university enrolls and protects undocumented students. There is a campus protest by a group opposed to enrolling and legislated money to give scholarships to undocumented students. They appear in sombreros, bandanas, a not quite blackface, but total ridicule of a student population. On the one hand, we're supposed to tolerate that protest. On the other hand, within the egalitarian underpinnings of the connection between speech and democracy, this is a group, I'm choosing this example, this is a group that is trying to silence to the point of exiling, eliminating from campus, an entire group. And you're in the state of Texas where these things have tremendous resonance, so that the university is a tiny oasis in a very tense situation. What would you want me to do as a professor to sort of, let's put aside the law of the First Amendment and just talk about the social norms. What do I want the next generation to inherit about that norm in a case like that? I mean, does Penn have a position on a thing like that?
I mean, here's what we would say, I think. It poses a hard case. The university sort of has this dual role. And on the one hand, it's a forum for all ideas. And, if a student group has organized that protest, I would say the university should not shut it down just because it knows that the content, and the costumes and whatnot are going to be offensive. At the same time, I think the university has an obligation to speak. It's also a moral actor. And I think it has an obligation to speak out very forcefully and vociferously at a high level to say, we reject this, and reaffirm, if they have a policy that allows those students to enroll, that protects them in some way, to affirm and reiterate that, to offer support to students, for whom that protest is, it's not just offensive. I think it can be, I do accept at some level it can be, really undermining and psychologically damaging to be on a campus where that is taking place. So I think it's a dual role that they have. It's not a comfortable position. Nobody will be entirely satisfied with that answer, but I haven't thought of a better answer than saying they shouldn't shut it down, but at the same time, they need to very strongly reaffirm their values.
In the late 60s, there was a dispute on several campuses, one of which the school where I attended, University of Chicago. The faculty committee did a report, and the one principle they could all agree on was that universities, speaking in their corporate capacity, should not take positions on matters of social dispute. That a university has this remarkable academic freedom and this special social role so as to bring individuals together who have very different ideas and protect them in contesting with each other, but that universities in a corporate capacity need to play this special role and not. Now, the example you give, it seems to me, would be a real test for that, because you know that the students engaging in this protest, ridiculing other students, are going to say, well, you've taken sides now, and at least in your corporate capacity, you shouldn't do that. The university can say, well, we may not have a role to take sides in most issues on the political agenda, but this has to do with our functioning as an educational institution, and to have some of our students subjected to this kind of ridicule, we do have a stake in that, at least, in a way that in a classroom, I would have no compunction as a teacher in my classroom kicking a student out of the class who repeatedly engaged in racial or gender epithets or even stereotypes, mocking fellow students in that class, because it would ruin the capacity of conducting the class. So how should we think about the university's role as a in a so-called corporate capacity in problems like this? How much does it need to not take substantive positions? Anyone?
I guess I'd have to. I would want to read the Chicago policy on this. I'm having trouble with this, in the sense that I think it would be important to know if these are. If this were government regulation in the sense of the police force of the city or county regulating protest, I think I'd have a different answer. But I don't really, even when we're talking about a public university. And I'm not talking, we're out of First Amendment doctrine. This is not a doctrinal position. I don't have a problem with the notion that a university is not in any sense a public forum. It's the kind of, it structures its environment, it structures who participates in its environment, it chooses its students, and it has some leeway in doing so. I think it would be inconsistent with the notion that the university has the freedom to choose its students. To say that it doesn't follow from that that it can limit student speech on the grounds that it is demeaning to or offensive to other students, or denies their equal citizenship, or makes it difficult for them to learn. I think any individual administrator has to exercise that power in a responsible way, obviously. But as a matter of the ethos of a university, I don't really see this as a difficult question.
Leslie, what do you think?
Well, I speak with some hesitation because although, and let me say this at first, I do think that campus speech issues are very important and that universities are incredibly important institutions. I do think there's a tendency among those of us who work at universities to get maybe overly distracted by campus speech politics issues. And that can detract focus from much larger issues that are going on, including First Amendment related issues that are going on outside universities. So I want to maybe extract out a little bit from this and say, the thing that I find difficult about these campus speech issues is the same thing that I find difficult on the question of toleration generally, which is what you have is the First Amendment being pushed up sort of against the wall of the liberal paradox. You know, liberalism is neutral about everything except about neutrality, right? It endorses neutrality as a value. It also endorses other things as values, including the equal dignity and desert of equal respect of all citizens. The university is an institution that should treat all of its students as deserving of equal respect and having equal dignity. And our polity is also that type of institution. Those are values that we endorse. So what you have really is a question of how far do our values of toleration for speech go? Is there a point at which they start to come up against these liberal democratic values that, that our institutions stand for, and how do you work that out? And I think that's kind of the core of the dilemma that Suzanne is talking about and why those cases are so hard. And it's very akin to the dilemma that courts faced in the early 20th century about anti-democratic speech. What do we do about socialist speech? What do we do about communist speech, speech that rejects the core precepts of our democratic system? What do we do with illiberal speech is a challenge, and I would just suggest we should have some pattern recognition about seeing that problem and how it recurs in various contexts.
Let me test this with one specific example, and then let's open it up for a Q&A. Most universities now have a procedure relating to outside speakers in which student groups make the decision about whom to invite, and central administration makes sure that it really was a genuine invite from a genuine student group, but other than that, tends not to block speakers. And of course, now we've had a dynamic in which some student groups go out of their way, it appears, to invite outside speakers who will be particularly provocative. And there are certain outside speakers whose at least style and probably content is designed to be provocative in the sense of producing a reaction, and often it turns out to be violent protests against and even physical damage and so forth. Suppose universities should decide to change the policy and to be more centralized in terms of what outside speakers are invited to speak on campus. And suppose universities particularly try to differentiate between speakers across the full spectrum of political views whose at least basic style and content is academic or maybe by some measure responsible, compared to other speakers who are thought to be not engaged in anything that could lead to a constructive dialogue or the like. So that, to be specific, Yiannopoulos is out, maybe Ann Coulter is out, Charles Murray is in. It wouldn't surprise me if universities started trying to draw those lines in a more centralized way as a way of dealing with these problems that have emerged. Is that inappropriate? Does that put universities in the position of imposing standards of rationality or civility that it's not the business of a university to impose? Any reaction?
I would be against it. I think that centralization is letting the university go against the basic John Stuart Mill principle, which is to take away from students the freedom to choose what they think is important to hear, and to have one central decision about which ideas pass some test, I think, is a threat. So I want to be clear about my schizophrenia here. Tolerance is a beautiful and eloquent idea. It is your Maginot Line, and if I were litigating any of these cases, I would defend that protest I spoke of. I would argue against this. I would hold the line as a litigator about the symbolic importance and the legal power of the traditional tolerance ideal. But I just don't think law operates in a vacuum. And as a teacher, just as a citizen, as a Facebook user, I think there's this disconnect between what law can do and what the surrounding, there is a degradation here I mean, something's under siege. And so if we took Leslie's initiative and sort of tried to expand it from the campus, so you could imagine there's a protest on campus. There's also a Facebook issue where maybe someone posts the video. Now, so you have this problem of what the standards are on campus, but you also have the problem about these powerful new actors who are private. The First Amendment doesn't apply. We don't really have any considered doctrine yet about, you asked this question about private actors and to what extent, just to be doctrinal for a second, public forums and limited public forums and common carriers, to what extent any of that applies to Instagram. Are they just free to make their own decision about whether to publish a nude picture or publish what this particular protest? That allows a tremendous opt-out in the connection between speech and democracy to the key channels of communication.
Yeah.
So I worry about that opt-out that's going on in our culture as well as the university part of it.
Others want to address?
But you already have that to some degree. You have other kinds of campus speech, whether it's a commencement speaker, or somebody who's invited by a department. I mean, there the university applies its standards and its viewpoint. But I agree that to declare that all campus speech and speakers are going to be handled centrally and that students don't have a role, it would really undercut what I think of as the role of the university and how students become educated in choosing what perspectives to listen to, learning how to argue back. So I think something great would be lost there. I think there's also a big distinction between the invitation, and this very liberal policy around invitations that you've outlined, which I think operates on most campuses, and then the disinvitation, and to me, where the one should be as kind of open as possible, the disinvitation should have a very high bar, because that's really where, to have a policy that any student group can invite anybody is viewpoint neutral. I mean, that to me upholds, I think idea that those Chicago principles we're trying to get at, which is that, at least on the one hand, the university has to be a forum for all ideas, but then to disinvite, is to take a position and to silence. And I think that needs to happen in only the rarest of circumstances.
Let's have questions. Far back there. No, you black shirt.
Oh, great. Nicko, I'm Director of Communications at the Foundation for Individual Rights and Education. Yes. My name's Nicko. I'm with FIRE. We've heard a lot of discussion this morning in both panels about Donald Trump and then sort of like the civic value of free speech. I was wondering if that's really where the First Amendment is under siege right now. Is it with the students on campus, or is it with the public at large that's dealing with misinformation campaigns, whether they're in the United States or abroad in places like Turkey or Russia? Or are First Amendment values also under siege in the legislative branches or in the courts? Because I haven't heard much discussion this morning about what the courts are doing with the First Amendment.
Anyone want to?
Sure, I'll say a bit. I think my sense is that First Amendment values, I hesitate to use the word siege because I think that might overstate the problem, but I think First Amendment values are certainly under threat, but I think that they're under threat from other plausible First Amendment values, right? And so, as I think about a whole range of issues, not just campus speech, but when I think about campaign finance, for example, is a pretty obvious one. For me, the First Amendment's on both sides of the ledger. I think in our courts, I think is a broader problem than a First Amendment problem. But I think American courts have a lot of trouble dealing with problems in which they understand rights to be on both sides of the ledger. They tend to like to think about problems as there's a right on one side, there's a government interest on the other side, and maybe some balancing has to happen. But I think we need a better language for thinking about situations in which the government's interest is a constitutionally informed interest. And again, the U.S. courts, I think, don't tend to talk in that language, but I think that language is essential for the First Amendment.
Susan?
I would echo what Jamal said, and a point here, and I think this is a point that's been touched upon by many people, but part of what both courts and legislatures do is try to shape values in a particular context. And I think it's easy for us in talking about First Amendment values not to recognize the relationship between facts and values. And I don't have any answers. I don't even have a good pithy diagnosis of the problem of what we have right now. I think what we have is a lot of rhetoric that's anti-First Amendment at the same time that we have a lot of rhetoric that's pro-First Amendment, but that the different values behind these different instances of rhetoric, if you dig a little deeper beyond just the fact that people are putting the First Amendment label on it and it somehow involves something that's made of words, the values tend to be quite different. And getting underneath there is difficult. And I think that that's part of what Jamal is alluding to, that if you break apart the idea of First Amendment values, you'll see lots of different values and values that actually trade off against each other. Just another point, and this is something that people have alluded to, the trade-offs and the balancing of these values I think tends always to take for granted the factual assumptions of the people who are making the decision. And then you get a doctrine that is divorced from those factual determinations, but kind of arose from the factual determinations. So for example, I think the actual malice standard is something that comes out of a particular factual framework that built in certain assumptions about what journalists do, the relative frequency of misinformation, the likelihood that misinformation would be intentional versus inadvertent, and the overall value of the press to society. And in that particular case also, factual awareness of how libel law was being used in Alabama with regards to the Civil Rights Act. So lots and lots and lots of different factual pieces of information going into a standard, which then becomes a very permissive standard that kind of floats free of those factual determinations. And it's gone even further with a lot of lower courts saying, when it comes to the campaign context and people making statements in the context of a political campaign, we think not even the actual malice standard is appropriate. Essentially what you have to have is complete immunity for statements, regardless as to whether they are true or false, regardless as to whether they were deliberate lies. Now that determination, I think, takes place against certain assumptions about what's going on in society. Because to me, I look at a standard like that and I think what's happening here is the type of value balancing that Jamal's talking about. And courts never say that's what they're doing. And they'll say this is a categorical balancing or whatever, or they won't say the actual malice standard is about balancing, but on some level they're doing some sort of value assessment. And the courts that have come to that conclusion, I think, have decided, the risks, our distrust of government, our distrust of the government being the one who determines what the truth is and being the arbiter of that, our worries about that so outweigh the risk of false statements within a campaign context that we decide not to regulate. If facts change, that balance changes too. And you might still have an enormous distrust of the government, but the likelihood that people are going to make deliberately untrue factual statements in the context of a campaign is something that might fit into the balance. And our doctrine isn't very good at being candid about the fact that it's doing balancing or that it's taking into account facts on the ground. But I think it is, and I think that's part of what makes the moment that we're in so difficult, because it's hard to figure out what the facts on the ground are, and all we know is that they're definitely changing.
Other questions? Ma'am? Oh, whoever's got the mic, okay.
Vince,
Hi.
what a pleasure to hear you think in less absolute terms. I had the pleasure of studying with Vince, and I think the private sphere question is a really interesting one, and I appreciate that we do make value judgments every day. Back for a minute, if we could. I'm sorry, I'm Eve Burton. I'm the general counsel at the Hearst Corporation. And back also to what Jamal was talking about. In the context of colleges and universities, I think it really is a great ecosystem for us to consider solutions or not, depending on our views. But I go back to, Vince, what we learned from Alexander Michaeljohn when I was at Columbia Law School. And he famously wrote, which I pulled up, "The First Amendment is not the guardian of unregulated talkativeness What is essential, he said, is that everyone, not that everyone shall speak, but that everything worth saying shall be said. And he was speaking as the president, I think, of Amherst College at that point. So coming back to your question and your sort of proposal, could you have something that was, we've looked at it as sort of decentralized with students or centralized with universities, but could there be something that was sort of more of a true content-neutral gating system so that you actually got the very best speakers on every side of the social spectrum? We do that in curriculum. We do that, as someone said, in admissions for colleges and universities. I mean, to just say it's too hard to do when we're outside of the core speech, which I feel very differently about, when we're outside of core speech, isn't it actually more productive to more speech if you can hear each other and have some process by which you desensitize the violence that's occurring on campuses by having a very robust, not vetting process, but discussion process prior to the speech coming onto campus? And I'm wondering if you all could just talk a little bit more about that. I take our colleague from Texas doesn't like that, but is there something more that could make that more First Amendment friendly, but also begin to bring more debate and dialogue actually to campuses?
I mean, to me, kind of, I don't know if I understand it that well, but it sounds like, how faculty are chosen. It's like the very best that a university can bring on, and those are people who are given a platform, day in and day out to shape the discourse on campus. I think with speakers, it's more ephemeral, and I think the problem is, who decides what is the very best? They're genuinely different views. I mean, there are, views that we might, collectively just categorically reject and think are ridiculous and are fake and mendacious, that somebody else, would think are really credible and need to be heard. And so I don't think you can separate it from politics. I think the very high standards that apply for hiring faculty and scrutinizing their work and inviting someone to be a part of a campus, I think there's a good reason to have a different level of people who are allowed to enter into discourse. Because, it's not like their ideas won't be heard. They'll be heard on social media and on the internet, and never tested in a forum like this where people can kind of push back and unpack and, dismantle their arguments, and students, get to see that give and take. So I think the idea that, in this day and age particularly, that kind of not inviting someone to campus or disinviting someone from campus means their ideas are completely excluded, is also not correct. So I think kind of airing it out, if there's a student group that wants to invite, allow them to do so and air it out and try to keep it peaceful.
Other questions?
Can I just,
Yeah, oh, sure.
so trying to respond to both the fire and the general counsel Hearst together. So just consider these things off campus. I mean, recent Court of Appeals decision saying that the government can close the Jefferson Memorial to protest. It was a silent expressive dancing. Just close it. Can just have an absolute ban because it's government property. So no First Amendment analysis at all. Public employees, recent decision saying public employees, when they whistleblow, if they're speaking as an employee when they whistleblow, do not get First Amendment protection. Compare those recent cases in which, even as the First Amendment expands in covering videos and other things, the opportunities to speak that government wants protected are shrinking. Compare it to one of the most important events judicially in the civil rights movement, which is in the final Selma to Montgomery March. That required, since it was now going to be thousands of people essentially closing the highway, the main thoroughfare, which is not a traditional forum for speech when it's thousands of people, that required a federal judge to impose on government an obligation to open up that highway to that protest, to that speech, because he made the substantive argument that you can't be blind to the connection between speech and democracy. The highway. I don't think you'd get a federal judge today I don't know what the interstates are here. Closing I-95 for a march between Boston and New York, I just don't think you'd get any kind of legal analysis saying that, that could be used for a woman's march or whatever. And so I think there are these implicit threats legally that are going on. And then just one other thing while I have the table. So judicial decisions, competitors to Google will sue Google claiming that they falsified their ratings on the first page. As you know, if you're not rated on the first page, you might as well not exist. First Amendment applies in courts. Google is treated as if it were a pure opinion speaker, that ratings are just its opinion. And therefore, the First Amendment, ironically, closes to courts, to courtrooms, even the ability for a rival company to try to hold Google to account. So I worry about this combination of declining public space or opportunity to speak. The Jefferson Memorial is not a place for protest. And this increasing power of private entities to use the First Amendment, to just sort of hold themselves unaccountable. Those two things I think are frightening.
Jeffrey, just on that, I think of that as the donut, that public employee speech, public spaces, and their availability for speech, these are kind of core issues where you see some hollowing out. And then you've got search engines claiming basically immunity from fair competition laws, and ISPs claiming immunity from net neutrality laws. That's the donut that's surrounding this increasingly empty space.
This prompts me to make an observation. I teach the classics, the old thinkers, and often I'm asked, do these people have anything to tell us about our modern free speech disputes? And the skepticism comes from the perception that all these people, and I'm talking about Milton, Madison, Mill, Hand, Holmes, Brandeis, they talk about speech as though it's about truth-seeking, it's about learning from each other, it's participating in a larger conversation. So much of the modern speech disputes are either about leveraging your own power through words, or back to Tim Wu, getting attention. The reason you want to have the power to bring hundreds of people together in a march is to get attention. The reason you want to burn a flag or use a swear word in a courthouse corridor is to get attention, so that in a way that these modern disputes are so often, and partly because of these other forces, about matters that are not what the sort of historical analysis, was largely about. Questions? No.
Hi, I'm Vicki Baranetsky from the Reporters Committee. And my question, I think, dovetails actually very nicely from this just last conversation, which is the answer, do we think more of the answer lies in technology or the law? And to marry the first panel with this panel, I think one way to look at it would be, does attention disrupt tolerance? So perhaps in a technological realm, we have so many blasts of tweets, of ideas, and it's not the same thing as sitting and tolerating an idea in the way that we're used to. And perhaps that's not something that can necessarily be fixed by doctrine. And I guess I'm just wondering a response, a reflection on that notion.
You want to take it?
Well, I think of this as a problem of sort of East Coast code versus West Coast code. The U.S. reports the codes over here and the statutes over here versus the sort of West Coast technology-driven coding solutions to things. And to some extent, I think East Coast code is always following and trying to keep up with West Coast code. You can't sort of regulate the directions that West Coast code is going to take us. I don't know if I would locate a solution in either place necessarily, and I don't know that there are solutions. I think we certainly can't stop the train of technology. One thing we can do is try to be mindful about these things and think about how these things interact with each other, and also, you know, on the jurisprudence side of things, I don't have a perfect formula for what the First Amendment is or how you trade off values, but I think what's clearly not the right answer is to say because something is made of words, therefore it gets full immunity under the law. And just because code can be characterized as information, therefore Google is immune from any sort of antitrust regulation, and there's absolutely no way that East Coast code can regulate West Coast code. So I think we can recognize what's not the answer, although I'm struggling to figure out what the right answer is.
Can I just, just to add a little bit to that, we've been treating, speech words are a heuristic. At least that's how I like to understand protection of speech in the Constitution. The court, and this is consistent with Snyder versus Phelps, where I think this is said almost explicitly, treats speech as if it's the thing. Right? If it's in the form of words, then that's the end, and that's what we're interested in. I think part of the problem that I think the question identifies is that courts like to have rubrics for solving future problems, right? And they like to govern by rules. We've in a lot of ways and for lots of reasons lost our ability to govern through laws and through actually experimenting with policy, as opposed to thinking about the First Amendment as this is just a thing that the courts employ in order to regulate speech. It's a backstop in some ways. There are going to be lots of areas in which the First Amendment doesn't matter because it doesn't actually implicate the types of regulations the courts are interested in, without thinking about, well, are there ways in which we can use policy to shape freedom of speech and to shape free expression? And then the question becomes, what do courts do with that? And then my answer would be, courts need to show some degree of respect for the complexity of the problem being identified, the deliberative process that goes into crafting a policy solution to a problem, and then we look at what the details are, right? And we have to, so it's not just about courts crafting rules, it's about coming together to try to think through policy, sometimes by government, sometimes it'll be by private actors, but we've sort of lost that as part of our free speech discussion.
If only we had another half hour, all would be revealed, but lunch is next, and that takes priority.